Welcome everyone to our webinar on refunds, returns and repairs, your business's legal obligations. My name is Stephanie and I'm a lawyer in our commercial practice. I'm joined today by my colleague Saya, who's also a lawyer in our commercial team. It's wonderful to have you join us today. Just before we begin, I'll run through a couple of quick housekeeping items. So, you will be emailed the webinar recording and slides following this presentation sometime this afternoon. So you can look forward to that to be able to review the content that we talk about today. Throughout this presentation, you'll also be able to submit your questions in the chat box, and Saya and I will have some time to answer them at the end of this presentation. If you have some time afterwards as well, there's a quick 30-second survey at the end of the webinar that would be really helpful for us so that we know a little bit about who's come along. And all attendees are eligible to receive a free legal consultation with us to discuss how we can help you with your contracts or any of your legal needs. And to request that free consultation, if you just provide us with your contact details in the survey that appears at the end of the webinar, we'll be able to make contact with you. So today, what we're going to be discussing is the consumer law, your obligations under the consumer law, what the consumer guarantees are, what happens if you fail to meet those consumer guarantees, and the solutions that you have to offer if there is a failure, the refunds, returns and replacements, repairs, and some sundry other solutions. And then, as I've said, we'll have time for our Q&A at the end. So, to kick us off, Saya is going to speak now about the consumer law.
Thanks, Steph. Hi, everyone. Thank you for joining us today for this webinar. I'll start by discussing what the Australian consumer law is, which we'll also refer to as the ACL throughout this webinar. The Australian consumer law is legislation that creates mandatory standards of quality, which apply where businesses supply goods or services to consumers. So, who is a consumer? Well, a consumer can be a business or an individual. A consumer is a party who purchases goods or services, the value of which don't exceed $100,000, or who purchase goods or services for personal, domestic, or household use, even if those goods or services cost more than that $100,000 threshold. Which businesses does the ACL apply to? These mandatory standards of quality will generally apply to all businesses who sell goods or services to consumers in the course of trade or commerce.
So we know that the obligations are pretty broad. It seems like the consumer law applies to a lot of businesses. So you might be wondering, what are your obligations under the ACL? As we've said, the ACL creates those mandatory standards of quality, and they come in the form of a series of rights that are afforded to consumers that cannot be excluded. These rights assure consumers that the goods or services that they buy will be of an acceptable quality. The consumer's rights under the ACL can't be taken away, they can't be excluded in any way. And for that reason, they're guaranteed to the consumer no matter what, and are known as the consumer guarantees. Your obligation under the ACL is to meet the standards, provide the guarantees to consumers, and make sure that your goods or services meet that guarantee. They fit in with what the standard is. So let's talk about an example where we know the consumer guarantees will apply. A dental practice buys a portable air conditioner for use within their practice for $500. We know that the dental practice is able to claim the consumer guarantees and that the person who provided the aircon must meet the guarantees. This is because the air conditioner is less than $100,000 and it's not being resold by the practice or being used up in the course of the practice's business. So it's covered by the consumer guarantees. Saya is now going to touch on how the obligations may differ if you're a supplier or a manufacturer. Saya, if I manufacture pens and then someone else sells those pens, who's liable to meet the consumer guarantees?
Good question, Steph. This is tricky, and I aim to clarify your question in this part of the presentation. Firstly, your obligations under the ACL may differ depending on whether you are deemed to be a manufacturer or a supplier at law. And you can see the different obligations on the slide. But what do these terms manufacturer and supplier actually mean? Well, a manufacturer includes an individual or entity who grows, produces, or assembles goods, or holds themselves out to the public as being the manufacturer of certain goods, or permits others to use their brand name in relation to goods. In addition to this criteria, if you import goods into Australia from an overseas manufacturer, you may be deemed to be the manufacturer of goods at the time of importation if the actual manufacturer does not have a place of business in Australia. Now that we know about manufacturers, let's turn to suppliers. You will be taken to be a supplier under the ACL if you supply goods by way of sale, exchange, lease, hire, and in relation to services if you provide, grant, or confer a service. Under the ACL, certain guarantees are provided by suppliers and certain guarantees are provided by manufacturers. So, for example, if you are deemed to be a manufacturer under the ACL, you will see that you will guarantee the reasonable availability of spare parts and facilities for repairs. You will note that this does not apply to you if you are a supplier. In the reverse, if you are a supplier, you will guarantee that the goods you sell are reasonably fit for the purpose for which you represent that they are fit. This does not apply if you are a manufacturer. The distinction between manufacturer and supplier at law can sometimes be tricky. So we advise seeking professional legal advice to determine whether you are in fact a supplier or a manufacturer under the ACL, and accordingly, what your obligations are. However, there are some guarantees which are provided by both manufacturer and supplier as outlined on the slide. Later in this presentation, we will talk more in depth about this. In the meantime, I will discuss the statements you can make about the consumer guarantees. Under the ACL, you need to be very careful about the statements that you make, and you must be aware of how you make those statements. For example, you cannot restrict, modify, or exclude the consumer guarantees or represent that you are limiting them in any way. For example, you cannot include a clause in your agreements with consumers that are inconsistent with the consumer guarantees. If you do this, these terms will be void and you may face penalties for providing false or misleading information in addition to breaching the consumer guarantees. A classic example of this is a business that presents a no refund sign in its store or includes such a term in its contracts with consumers. A sign or term like this suggests that refunds are not possible in any event, including where there is a problem with the good or with the service. This may mislead consumers into thinking that they are not entitled to a refund under any circumstance. The key thing to remember here is that the consumer guarantees will apply automatically, regardless of whether your business stays silent on them, seeks to limit them, or otherwise excludes them completely.
Thanks, Saya. So we know that the consumer guarantees apply broadly and automatically. They can't be excluded and they likely apply to you as a business, whether you are a supplier or a manufacturer. We know that the consumer guarantees are the promises you're obliged to make to consumers about the quality of your goods or services. Saya has hinted a little bit about what the content of those consumer guarantees are, but let's get into some details. If you provide goods as a part of your business, you're obliged to guarantee that your goods are of acceptable quality, will match the description you provide to consumers, like what may be shown in a catalogue, a commercial, or a demonstration model that a consumer may use in store. You must also guarantee that the goods are fit for the disclosed purpose, that consumers can use them how they wish, and they match any express warranties that you make. So for example, If you warrant that a good will work for a particular purpose, or that you will take care of it for 3 years, this becomes a consumer guarantee for the purposes of the ACL. In addition, if you supply goods, you also have to guarantee that the goods have a clear title. This means you must ensure that it's clear who the goods belong to and when the consumer actually owns them. This means that your contracts or your sales terms should include some detail about when title will pass to the consumer, typically upon full payment of the price or when the goods are delivered to the consumer. And on a related note, you must also make sure that the goods do not have any undisclosed securities attached to them. So an undisclosed security would mean that another person has some claim to the goods, such as where it is a second-hand good and has been sold to a consumer, and the person who previously owned it used it as a security for a loan. When the financier comes calling and the consumer didn't know that there was an undisclosed security attached to the good, that is when the supplier must provide a remedy because they have not met the consumer guarantees. For services, there are a couple of different types of consumer guarantees. A supplier of services must guarantee that the services are provided with due care and skill, are fit for any specified purpose, and that the services are provided within a reasonable time, if no time specifically is noted. This often has some ancillary promises attached to it. In order to fulfill the standard of due care and skill, you must be using an acceptable level of technical knowledge or skill when providing the services and taking all necessary care to avoid loss or damages. So for example, this consumer guarantee would not be met if a consumer hired you to fix a leak in their bathroom and, after you provide your services, the same leak is back the next day. This would allow for the consumer to claim that you did not perform the services with due care and skill. Delays in the provision of services are also a discretionary consideration with the consumer guarantees. If you're hired to replace tiles on someone's roof, but it rains every day for a month, then the consumer cannot claim that you haven't met the consumer guarantees. However, if the weather is fine for the month and you still haven't actioned the services, this is where the services would not have been provided within a reasonable time period and the consumer guarantees not met.
Thanks, Steph. I'll now discuss who must provide the consumer guarantees. Whether a manufacturer or supplier is required to provide a specific guarantee will depend on which consumer guarantee was not met. As mentioned earlier in this webinar, some guarantees are provided by suppliers, some by manufacturers, and some are provided by both. So, if a supplier has failed to meet a guarantee, a consumer must approach that supplier for an appropriate remedy. If a manufacturer has failed, then the consumer must approach that manufacturer. However, if a guarantee is provided by both supplier and manufacturer, then under the ACL, a consumer can take action against the supplier or the manufacturer or both, provided that the consumer does not seek to recover twice in respect of the same claim. Claims against suppliers must be made within a reasonable time, and against manufacturers no later than 3 years after the consumer becomes aware or should have reasonably been aware that the relevant guarantee had not been complied with. Further, if a consumer goes to a supplier stating that the goods are not of acceptable quality, and as we now know, this guarantee is provided by both the supplier and the manufacturer, the supplier cannot refer the consumer to the manufacturer to deal with the issue and provide a remedy. This would amount to a breach of the ACL and penalties would likely apply. Steph will now touch on how you should deal with a failure to meet the consumer guarantees to avoid facing penalties.
Thanks, Saya. So when you fail to meet a consumer guarantee, you're obliged to offer certain solutions to consumers. The types of solutions that may be offered will depend on whether it is a minor defect with the product or a major defect with the product. And generally speaking, if you fail to meet the guarantees as a result of a minor defect, You as a business can choose what solution you offer to the consumer. But if there's a major defect, the consumer gets the final say on what remedy they would like to receive. So let's quickly talk about what a major defect is and what a minor defect is. A major defect for goods means that the product is unsafe, it's significantly different from its sample or description, it has one serious problem or several smaller problems that would have stopped people from buying the good if they'd known about it beforehand, or the product can't be used for its normal purpose or its express purpose. That would mean if you had bought a pen or something of that nature and it simply did not write. For services, a major problem with a service occurs when it creates an unsafe situation. It has one serious problem or several smaller problems that would have stopped someone from engaging with the service if they'd known about them beforehand, or the services can't be used for their normal or express purpose. On the other hand, a minor defect with a product or service is much more loosely defined, and it seems generally accepted that a minor defect is any issue with a product or service that is not a major defect. So, if there is some major or minor defect with a good or service, you have failed to meet the consumer guarantees. And if you failed to meet the consumer guarantees, you're obliged to offer your consumer a remedy. And we will now discuss what those remedies are: refunds, returns, replacements, or repairs. And Saya is now going to tell us about refunds.
Thanks, Steph. So under the ACL, consumers may be entitled to a refund in certain situations. As we know, a refund is where a consumer is repaid the amount it paid the supplier or the manufacturer for the goods or services. When can a refund be offered? As Steph noted, a refund can be offered, for example, when a business sells a product with a major defect or a product that later develops a major defect. In this case, the business must give the consumer a choice between a refund or a replacement of the same type of product. In some cases, a refund of the price may not be a sufficient remedy, especially where the consumer has faced additional loss as a result of the defect, for example. Let's consider a scenario. Say a consumer purchases a new desk for their office. They set up the desk in accordance with the instruction manual and place their computer on the desk once they've set it up. The desk breaks a few days later and their computer falls. The computer screen is now damaged. In this situation, the consumer will likely be entitled to a refund for the price of the desk, but may also be entitled to consequential losses, such as the price for repairing their broken or damaged computer screen. In addition to refunds, consumers also have the right to a return or a replacement, which Steph will now discuss.
Thanks, Saya. That's right. The return or replacement of a good tends to come hand in hand with the refund of a good or service. Typically, this is because it's not often that we bring back a product like, let's say, clothes, for example, and we only want to return those clothes without getting our money back. It primarily relates to the provision of goods, this particular remedy, and consumers can choose to return the good and ask for a refund, or return the good and ask for an identical replacement. That replacement must be of an identical type to the goods that were originally provided and have been returned by the consumer, or if that's not possible, you can offer something of the same type and similar value. Otherwise, the consumer has the option to choose a repair or simply a refund instead. The consumer actually has the obligation to return a faulty good to you unless it cannot be done without significant cost to them, in which case you must collect that good at your own cost and within a reasonable time. An important thing to note here is that where a consumer is provided with a replacement good, the consumer guarantees apply to that replacement as though it were the original good. Let's say a customer buys a shiny new phone and due to a major defect, they want to return it and get a replacement. That replacement phone has all of the same consumer guarantees that the original faulty phone would have.
Thanks, Steph. I will now touch on repairs, which is another remedy available to consumers under the ACL. When can a repair be offered? If a failure with goods is not major and can be repaired within a reasonable time, the consumer cannot reject the goods and demand a refund. Instead, the business may choose, in its absolute discretion, to provide the consumer with a repair. If a business is offering a repair, it must fix the problem within a reasonable time. Now, what is reasonable will largely depend on the circumstances. Let's consider this example. If a consumer is having issues with an essential household item, for example, a kettle, which is typically used most days, if not every day, the business will be required to repair this much quicker than it would for something that is not as essential. For example, a lawnmower, which may be used every few weeks or so. Where the kettle cannot be fixed within a reasonable time, the consumer will be entitled to another remedy. For example, a refund or a replacement for the same kettle or a similar kettle. The consumer has no option but to take the kettle elsewhere for repair. For example, where the supplier cannot repair the kettle within a reasonable time, the consumer does not have to get the original supplier's agreement to take that kettle to another supplier for repair. However, in a case like this, the original supplier will only need to pay the reasonable costs of repair. Again, what is reasonable will largely depend on the circumstances and will be determined on a case-by-case basis.
Thanks, Saya. So let's talk about some of the other solutions that may be relevant, some of the other remedies that can be given if a repair, replacement, or a refund are not appropriate. Some of these might even go hand in hand with those earlier solutions that we've talked about. The cancellation of a service contract often goes hand in hand with the return of a good and where you receive a refund for parts of a defective service paid for and not used. So where goods are connected to a service contract, such as where a consumer orders a good and the services are to install it and maintain it over a period of time, and that consumer wishes to return the good due to a major defect, they may also cancel the linked service contract. And they can do this when they return the good itself or within a reasonable time after the return without incurring any penalty. If a consumer chooses to cancel a service contract for unsatisfactory services and it's linked to a good, they must return that good that is connected to the service, even if there is no issue with the good itself. If they've paid any money for the goods, you must provide a refund. Consumers are responsible for returning the goods themselves unless it would involve a significant cost to them, in which case you must collect the goods. And the cancellation will take effect when a consumer notifies the supplier that they want to cancel their service contract. I'll also just touch on compensation for damages and loss. This may come about if there is some consequential loss that occurs as a result of a defect, or in the case where a good or service has dropped in value as a result of a defect, but the consumer wishes to keep that good or service despite the defect. They may choose to keep it, but be compensated for what the difference in value is from what they bought it for and what it is now worth as a result of the defect. And a consumer may also seek compensation from a supplier for any consequential or associated loss or damage resulting from a failure to meet the consumer guarantees. That loss or damage must have been reasonably foreseeable and not caused by something outside of human control, like an act of God, such as a weather event. For example, let's say that a consumer hired a trader to build a deck on their house. The deck was not properly constructed and it collapsed, injuring the consumer and causing some damage to their outdoor furniture. The consumer may be entitled to compensation for their medical expenses and for the repair or replacement of the outdoor furniture that was damaged as a result, in addition to a refund for the cost of the building of the deck. So you can see that the consumer guarantees are quite broad and will apply in many situations. It's best to be across your obligations and potential solutions to ensure that you can comply with the ACL. If you refuse or are unprepared to offer solutions where there is a failure to meet consumer guarantees, penalties under the ACL may apply. That brings us to the conclusion of the main part of our webinar today, and it's been an absolute pleasure to speak with you. If you would like to discuss any specifics of your business or how you can be even better prepared after watching this webinar, we encourage you to reach out to us here at LegalVision by providing your details in the survey at the end of this webinar, and we would be more than happy to assist. You might also find our publication useful, How to Recover Unpaid Invoices. You can access this by accessing the handout section in your webinar panel. And we also have another upcoming event that may be of interest to you, which is the Founder's Guide to Selling Your Shares. You can join our colleagues, David Kerr and Miles Guggenheimer, on this topic in March, which looks to be really interesting. We're going to have a chance now to answer some of your questions. While you continue to submit them, we'll take a minute to tell you about our membership model, which Saya is going to walk us through now.
Thanks, Steph. LegalVision's membership is a cost-effective alternative to the expensive hourly rates you often experience with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, including drafting, amending, and reviewing business contracts and commercial leases, unlimited advice consultations with our team of over 100 specialist lawyers, including business structuring, employment, disputes, and more, and unlimited domestic trademark registration. LegalVision membership is like having your own in-house counsel. We'll take care of all of the business as usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how membership can help you, request a free consultation when the survey appears at the end of this webinar. And now we will answer some of your questions. Steph will answer the first question.
Yeah, thanks, Saya. So this is an interesting one. If a consumer purchases a product online from an overseas supplier, what rights does he or she have if there's a fault with the product? Excellent question. When an overseas business sells products directly to consumers in Australia, the business must follow the Australian consumer law, including the consumer guarantees. So we know that they're obliged to follow it. In practice, it can be difficult to get a repair, a replacement, or a refund from an overseas business if there's a problem with the product or service. And the help that Australian consumer protection agencies can provide tends to be limited. Consumers aren't covered by the ACL if the business doesn't officially offer their products or services here in Australia. So for example, let's say a consumer has the business send the product to an overseas address, and then the consumer arranges for someone to forward it to their address here in Australia or bring the product back with them when they fly over to Australia. In that scenario, where the business doesn't officially offer their product in Australia, it doesn't apply. But if it has some sort of outpost here in Australia, even if it's an overseas-based business, the consumer guarantees apply. Saya, have we got any other questions?
Yes, we do. We've got a question which states, for skincare products which claim to be able to achieve certain results, if customers do not achieve the result after using the product, are they entitled to a refund? So this is a little bit of a complicated question because skincare products are regulated in Australia by the Therapeutic Goods Administration. So in addition to the consumer law rights that consumers may have when purchasing your skincare products, you as a business need to be mindful of how you are advertising your skincare products. You need to ensure that you are advertising in accordance with any regulatory requirements provided by the TGA or other bodies. I would encourage you to book in the free consultation at the end of this webinar to learn more about what your obligations are as the business when you are advertising skincare products or similar. Steph, are there any other questions that's come through?
Yeah, I've got another one here that says, what are the essential elements for refunds of sporting activities? For example, a term of gymnastics lessons. So I think that this ties back a little bit to what we were saying about the cancellation of service contracts. So where there is a cancellation of a service contract for any reason, if a consumer just wants to cancel, they don't want to take their gymnastics lessons anymore, there isn't necessarily an obligation to provide a refund unless your sales terms or your contract consumer has agreed to says differently. If they cancel the gymnastics lessons or any kind of sporting or recreational activity as a result of a major or minor defect, i.e. it doesn't match the description that you said that the gymnastics lessons would apply to, that is when we fall into the consumer guarantees and how they apply. That is when a refund would need to be offered for any of the services that have not been performed yet. So yes, there will be coverage for the fact that there is a major defect with the services that were provided prior to the cancellation. And as well as that, you'll need to provide a refund for any amount that the person has prepaid for services that they were going to receive and now no longer receive. So it's really dependent on whether they cancel just for any reason, they don't want the recreational service anymore, or if they cancel for a defect. If they cancel for a defect, consumer guarantees kick in, and that's when refunds will need to apply.
Great, thanks, Steph. We've had another question from an attendee. The question is a really good question. How would the consumer actually enforce their right to select a refund for a major problem? How does the consumer take action or make the claims you mentioned? Do they have to go to court, or is there an easier way? So the first step for the consumer would be to reach out directly to the supplier or the manufacturer, depending on which consumer guarantee had been breached. If they fail to get an appropriate response from the supplier or the manufacturer, they can reach out to the regulating body, which is the ACCC, or the Australian Competition and Consumer Commission. So the commissioner can then take action and investigate the claim by that consumer. In addition to this, a consumer may also have rights for a breach of contract. So in this case, they could make a claim for breach of contract, and as you noted in your question, yes, they could go to court to enforce that claim against you. So yeah, there are a few options for consumers, depending on who has breached that guarantee, it would either be up to the supplier or manufacturer to respond appropriately.
Yeah, we've got another one here, Sire, which is quite interesting. It says, with fridge repairs, for example, if the repaired fridge works for a few weeks and then stops working, the attendee has just asked us, where do we stand? This is an interesting one because it will depend largely on the circumstances. In these circumstances, we expect a repaired fridge to work for longer than a few weeks. I think in this scenario, if a consumer was going to come back to a supplier and say, hey, the repair has failed, the fridge is not working again, I would say that it would tend towards a failure of the consumer guarantees, because it would display that the services provided were not provided with due care and skill, because it was a quick fix rather than something that lasts for a long time. And as Saya talked about, when it's an everyday item that we use all the time, like a fridge that we just never turn off, the supplier is required to provide fixes for that within a sooner amount of time and to a standard that is acceptable for the type of service that it is, the type of product that it is. I expect to be able to use my fridge every day, I suppose. So we want to make sure that it's able to continue for that length of time. Of course, as Si's just mentioned, if this was to go to the ACCC or a court, we never know where we might land with their decision. But they tend to take a reasonable approach and a common sense approach to what the product or service is and what level we expect it to be repaired, replaced, worked on, to what level we expect from the particular services that are provided.
Great, thanks, Steph. We've got another question come in. The question is, I'm a footwear repairer. How long do I legally have to hold on to consumer goods before disposing of them? I'm assuming that in this situation, a customer has brought in their goods for repair. You are expecting payment after you've already done the work, and the consumer hasn't come back to collect their goods or to pay you. How long you have to hold on to those goods will largely depend on where your business is. So there's actually different state and territory legislation which outlines how long you must wait before disposing of goods. It will largely determine on the value of those goods in order to determine how long you need to hold on to those goods. We typically recommend putting in a very clear clause in your consumer agreements, informing them of how long you'll hold on to the goods before you dispose of them. But definitely reach out to us and give us a little bit more information about where you're based, so we can provide you with advice in accordance with the state or territory that you're trading in.
Thanks, Saya. There's another question that's just come through related to what you answered earlier. It says, can the ACCC make enforceable decisions for single cases? What about New South Wales Fair Trading? This is a great point. New South Wales Fair Trading also offer a complaints handling process. So consumers have the option to go through to the New South Wales Fair Trading website and receive some information from them about how complaints are handled. They're always encouraged to contact businesses in the first instance. So as a business, you should be aware that when a consumer reaches out, to respond to that quite promptly, because if there's no response from you, they are able to escalate their complaint to either New South Wales Fair Trading, other fair trading institutes, or the ACCC, as Saya has mentioned. And fair trading has a number of different resources that are available around tips and tricks, sample letters that can be provided to businesses, and also provides that complaints handling process, as I've mentioned. So as I say, it's important to be aware of when a consumer reaches out regarding a particular defect or issue that they may have. Often, consumers may reach out and claim that they have a major problem with a product or service. You'll need to be aware of what you actually have promised, what you are obliged to promise, and what they can actually be entitled to. Because sometimes consumers are not aware of what their guarantees actually are, and they may try to claim more than what they're entitled to. So it's an important balance to ensure that we are providing appropriate products to our consumers without going a step too far and paying them back much, much more than what they're entitled to, or on the other hand, which is also problematic, saying that they're not entitled to anything at all. So it's important to find that balance.
Thanks, Steph. Another question is, what do I need to include in my consumer agreements to ensure that I am compliant with the ACL? So as Steph and I have discussed throughout today's webinar, the consumer guarantees apply regardless of whether you actually include or reference them in your consumer agreements. As best practice, however, we always suggest including a clause in your consumer agreements, just outlining that consumers will have rights under the Australian consumer law. This is not necessary, and the consumer guarantees will apply regardless of whether a clause like this is included, but we do recommend it as best practice. It's important to note that you shouldn't include any clauses that seek to limit or exclude the ACL. This would amount to a breach of the ACL, and as we said before, penalties may apply. So you don't need to include a clause about the ACL, but as best practice, we do recommend it.
Yeah, absolutely. One more question that we've got here, Saya, is someone asking, as a medical device manufacturer, do the consumer guarantees apply to these kinds of goods and services? Absolutely. The answer is definitely yes, consumer guarantees will apply. Often, I'll note that with medical devices, it can become more difficult because the devices tend to be increasingly sophisticated and increasingly complex, which gives them more opportunity to fail or not be fit for purpose. And that fitness for purpose warranty will be a real sticking point in terms of the consumer guarantees. It ties in with an additional part of the ACL that we haven't touched on as much today, but is related, which is the obligation not to make misleading or deceptive claims about your products. These things tend to go hand in hand, because if you make a claim about your product and say that it will be fit for an express purpose, and then it is not fit for that express purpose, that's a failure of the consumer guarantees, and potentially a failure of making a misleading or deceptive claim to a consumer. So it particularly comes up for medical devices. It's important to make claims about exactly what your product can do and not make any broad strokes claims about what you want your product to be able to do for a particular consumer. If you're clear about the fitness for purpose, you're clear about what the purpose of the product actually is, this gives you protection for the consumer guarantees, and it keeps your medical device out of the murky waters of making a misleading or deceptive claim that a consumer will then rely on or follow up on.
Thanks, Steph. I think we've got time for one last question. The question is, are there circumstances when the consumer guarantees won't apply? Yes, there are definitely circumstances when they won't apply. For example, they won't apply for sales made at garage sales or for private sales, such as on Facebook Marketplace, for example. The guarantees also don't apply where you are purchasing goods for the purposes of resupply or distribution. So for example, if you are a distributor and you're purchasing products from a supplier and those products will be used by you for the purposes of distribution, then you will not be afforded the protection of the consumer guarantees. If you are a distributor or a reseller, we always recommend that you include strong obligations on the supplier in your distribution or reseller agreements. This is to ensure that you have some protection in your agreements where the products are not provided to you in compliance with any specifications or any arrangements between you and the supplier. So yes, definitely circumstances where the consumer guarantees don't apply, which is why it's a good idea in those situations to include clauses in your agreements that offer you the same or similar protections as the guarantees under the ACL.
Absolutely. There's a couple of really good questions here. I think we're coming towards the end of our time together. I would like to say that if you'd like to have any of these questions answered, it's really helpful for us to be able to have some extra time to be able to chat with you specifically, get an understanding of your business and how these questions apply to the kind of products and services that you provide. So if at all possible, please stay on for an extra 30 seconds after the webinar ends, fill out the survey, let us know your contact details, and that way we can provide a consultation, sit down with you and understand the real scope of your question and provide some really relevant feedback for you that can help you understand the sometimes complex application of the consumer law, particularly to your specific business and specific products and services. So we'd love to be able to continue to chat with you. So please send through your contact details and we'd be thrilled to be able to get in touch and understand things better.
Great. Well, thank you so much for joining Steph and I today. And as Steph said, we hope to chat to you after this webinar through a consultation.
Thanks so much. Bye, everyone.